Hello. Prior to the Disability Discrimination Act, people with disability had few and limited avenues to prosecute discrimination. Although state jurisdictions covered the ground of disability in their anti-discrimination laws. Australia has few human rights protections. We have limited rights enumerated within the Constitution, and what other human rights protections we have, be they statutory or common law, are piecemeal. During the 1980s, the original intent was to have a Human Rights Act, and anti-discrimination law was to be part of that. In 1985, we were promised a Human Rights Act. The Commission was established in 1986 around this idea, where anti-discrimination law would support that human rights framework by providing a right of action when individual situations of omissions or prejudice occurred. We are still waiting for the Human Rights Act. In the meantime, separate pieces of anti-discrimination legislation were developed, one of which was the DDA. The introduction of the DDA was seen as a watershed moment, and as with most bright new things, the DDA was highly anticipated and had great expectations placed upon it. Officially, the DDA objective is to eliminate discrimination, and it is to achieve this through an individual complaints mechanism, providing remedial compensation for people who have experienced unlawful discrimination. Whilst the DDA was not the panacea for discrimination experienced by people with disability, it has had some very positive achievements. From the beginning, the DDA has provided a very prominent recognition of the discrimination that people with disability experience. The very symbolic nature of having a law that prohibits discrimination on the ground of disability was very significant at a time when people with disability were still very much missing from public and political discourse and had very few options to pursue the discrimination they faced. Much of the discrimination experienced by people with disability resulted from systemic failures, acts of omission, and individual acts of prejudicial exclusion, where systems and policies based on ableist stereotypes, misunderstanding, and fear created systemic barriers to access. The appointment of people with disability in a leadership role, such as the Disability Discrimination Commissioner, from the appointment of Elizabeth Hastings, the first Disability Commissioner forward, has challenged ableist stereotypical notions of people with disability as being passive objects of social welfare, as opposed to active participants within our community. The Commission, through the DDA implementation, brought people with disability to the table at a time when people with disability had been isolated from public policy discourse as a result of ableism and historic disadvantage in education and employment. It provided space and brought people with disability into discussions with government, business, and industry. One of the major successes of the DDA has been the cultural shift in understanding that formal equality often results in discrimination, that treating someone the same doesn't always equate to equality. There is now an understanding that we need to move beyond treating everybody the same, and that policies of general application do not always result in equality. A strengthened regulatory framework through amendments to the DDA, including modernisation and consistency across the full suite of Commonwealth anti-discrimination laws, will ensure the DDA is fit for purpose. The overarching nature of the DDA is reactive. The elements that were built in it to be proactive don't have enough grunt. Action plans are voluntary. There is no role for the Commission to evaluate or review them or give compliance certificates. There is little guidance on where businesses could do things differently. The breaches in the standards, again, are triggered by individual complaints. They are not built into mandatory frameworks, such as licensing. The one success is elements of the access to premises standards, built into the mandatory mechanisms of the Australian Building Code. We all know prevention is better than cure. However, the DDA is currently framed around a right of action within an individual complaints mechanism that operates after discrimination has already occurred. A positive duty, if incorporated into the Act, would place obligations on duty holders to take steps to eliminate unlawful discrimination, harassment and vilification. This would bring a new significant focus on the prevention of discrimination by employers, education providers, providers of goods and services, sports clubs, etc. A positive duty focuses on bringing about systemic change, rather than focusing on trying to remedy individual problems. The onus is on the structures and systems to change rather than a reliance on people with disability to bring forward a complaint with the personal, emotional and financial costs that entails. It would promote substantive equality. A modernised regulatory framework would support a preventive culture. The value of any change is the extent to which it embeds an understanding of ableism and how it underpins inequality and discrimination experienced by people with disability. Where the DDA succeeded over many similar laws around the world has been its broad definition of the protected class. Whilst appearing quite medical and technical, it covers the broad spectrum of human diversity, including associates and imputed impairment. As such, it focuses not on the pathology, but the phenomenon of disability. The DDA has not become paralysed by litigation over whether a person has a disability as defined by the Act, the way many jurisdictions who have used a social model definition of disability have, most notably the US, resulting in costly and ultimately unproductive litigation. Even though one of the main successes has been the definition of disability, that doesn't mean that it is free from ableism. Disability in the DDA is currently framed as a negative deficit language. A contemporary definition would focus on the variations inherent in the human condition and recognise disability as just one aspect of human diversity. We've long acknowledged that sexism and racism results in interpersonal, institutional and systemic inequality and discrimination. Recognition of human rights is central to gender, race and First Nations policy agendas. Yet in disability, we consistently find that the language of disability, policy and discourse is so often framed in terms of inclusion, reaching their potential and focusing on abilities. It doesn't address the pervasive impact of ableism. Ableism is the basis of how society understands what it means to be human. Disability has for a long time been understood as an individual deficit or disorder, an individual problem to be heroically overcome or cured, or to be suffered, preferably away from the public eye. People with disability are devalued and seen as inherently vulnerable and in need of fixing or curing. Ableism is deeply embedded in legal, policy and practice frameworks and in everyday individual and community attitudes. It results in inequality and discrimination and is the basis for special and segregated settings for the care, treatment and protection of people with disability. The belief that people with disability are incapable of being part of the community becomes self-evident, and the segregation and exclusion of people with disability from community life is unquestioned. We fixate on the material difference of impairment and diagnosis, rather than questioning or transforming existing structures and systems that have been established to care, treat and protect people with disability, yet are commonly used as mechanisms to control and manage, and result in harm, loss of identity and autonomy. They are the basis for inequality and discrimination. This is the way in which society disables people who don't meet the narrow concept of what it means to be a normal human being. No one has the complete range of skills, talents and aptitudes for all situations and circumstances in life. And what society understands as impairment is just one aspect of the human condition and human diversity. We need to recognise that existing structures and systems are based on ableist, societal and cultural choices and practices that can be challenged and transformed to embrace and value human diversity. A modern DDA can challenge those practices, but it can only do it if it is underpinned by an understanding of ableism. It could provide guidance on the unique nature of the discriminatory experiences of people with disability, similar to the way in which sexual harassment articulates the type of conduct that fall within the prohibition. For example, conduct that indicates a view that a person is less capable or has less agency, that seeks to be overprotective or characterises a person with disability as a danger to themselves or others, that seeks to separate a person with disability from others even when asserted to be for a benevolent purpose. This has been explored by Dr. Robin Banks in her doctoral thesis. And importantly, a modern DDA would recognise intersectional complaints by adding on the ground of disability alone or in combination with any other federally protected attribute. To address some of the fundamental flaws in the DDA is the need to enhance access to justice and improve the practical operation of the law. The Australian Human Rights Commission supports consistency across all anti-discrimination laws and greater adjudicative powers to make determinations. The Commission has proposed the introduction of powers to enable us to be responsive, whereby we can enforce obligations rather than relying on limited persuasive powers. This would provide the Commission with a wider range of tools and leverage, such as monitoring and investigation, to drive greater compliance with obligations. One of the most difficult aspects of prosecuting a discrimination complaint is having to prove the motivation of the respondent. This means that the complainant needs to know what is in the respondent's mind. Shifting the burden of proof will require respondents to prove that their actions were not discrimination. They have more ability to explain their omissions or actions. Judicial interpretation in disability discrimination law has also been problematic. The DDA, in terms of statute law, is beneficial legislation, and there is a legal principle that beneficial legislation is to be interpreted broadly and purposively. Unfortunately, the Australian judiciary has tended to leave broad and purposive for their speeches and narrow and technical for their judgments. This has resulted in a narrowing of discrimination law and has had a detrimental effect on the DDA being able to achieve normative change. Michael Kirby, the former High Court judge, has famously commented that discrimination law was littered with the bodies of the wounded. And this has been true in regards to disability discrimination cases such as Purvis and Sklavos. In Purvis, a direct discrimination education complaint, which considered whether behaviour as a manifestation of impairment was part of the disability and what constituted the comparator in determining whether someone had been treated less favourably. After the court found it was behaviour that was inherent to the disability, the court then went on to find that some of the characteristics of the complainant should be ascribed to the comparator. In this particular case, when his behaviour was ascribed to the comparator, it was found that he was not treated less favourably. So a boy with cognitive disability who acted out by throwing his arms around and kicking his legs, directed at nothing in particular, but in response to overstimulus and a frustration of not being able to communicate that information, was compared to a boy who was willfully violent towards others. Purvis prompted legislative amendments with a degree of success, although there has been no judicial discussion or determination on how some amendments do or do not change the application of the law, and provisions are still being applied on the basis of Purvis. This has left the test confusing and difficult to apply, and at its core, illogical. In Sklavos, the High Court considered if there was a failure to provide reasonable adjustments. The judgment has prompted some academic hand-wringing. I feel I should note that I am one of the initial hand-wringers. The decision on the application of Section 5.2 of the DDA on whether the respondent had failed to provide adjustments is quite problematic. In His Honour's view, it is not enough that a person demonstrates a link between the effect of a respondent conduct and the applicant's disability. The disability must be a reason for the conduct itself. To take an example, the consequence of this approach is that a blind person who requires software to assist them to undertake a task at work must show that the failure to provide that software is because they are blind. These two cases exemplify the need for change and will now see limitations of the DDA in responding to discrimination. We now have an opportunity to modernise and strengthen the DDA through development of a preventative culture, modernising the regulatory framework, enhancing access to justice, and improving the practical operation of the law. It is only through such reforms that children and young people with disability, their families and carers, can enjoy their rights without discrimination. Thank you.